In the last several years, there have been a number of changes to Canada's criminal code for the purposes of dealing with trials related to SA. And these changes started as a result of the Jian Ghomeshi trial and have continued from there. There have been a lot of court decisions that have essentially created a process whereby SA trials become incredibly complex, incredibly prolix, and require a number of applications. And one of the changes that's being made in Bill C-16, the new criminal law bill that was tabled in Canada, is creating even more procedures for people to make applications to put forward certain types of evidence for the purposes of establishing their defense in their cases. It is increasing the complexity even more of these SA trials rather than reducing the complexity. And one of the big complaints that the public has had about SA trials is how long it takes them to get to court, and the fact that a lot of these charges are being stayed for unreasonable delay because the trials are not happening within a certain time frame. The bill goes on to try and address this a different way, which I'm going to come to in a different video, but the steps that's being taken here to try to deal with these procedures is only going to exacerbate that problem. The more you tie up the time that judges have in trials with applications to do things that judges already do a good gatekeeping function on, the use of people's evidence of prior sexual activity or a person's records and text messages and things like that, the more you tie up judicial time with that, the fewer cases that can proceed, because you turn a one-day trial into a 10-day trial by doing things like this. You have all these little applications that have to happen on certain schedules, and because they have to happen on certain schedules, the actual trial itself becomes further and further down the road. If you are concerned about cases getting thrown out due to delay, the solution is not to write in more procedures to make these cases more complex. The solution is to simplify the prosecution of these cases and speed up the process by which these cases are dealt with. And unfortunately, this bill does anything but that.